एवरीवन वेलकम बैक टू अनदर वीडियो ऑफ टेक्निकल लॉ। आज की इस वीडियो सेशन में हम बात करेंगे ऑल इंडिया बार एग्जामिनेशन का जो क्वेश्चन पेपर था AIB 20 उसके डिटेल सॉल्यूशंस के बारे में। ये वीडियो हमारा पार्ट 2 रहने वाला है। अगर अभी तक आपने पार्ट 1 नहीं देखा है तो काइंडली वॉच प्रीवियस पार्ट। सो लेट्स बिगिन। क्वेश्चन नंबर 37 है हमारा। इन द फॉलोइंग क्वेश्चन अ स्टेटमेंट इज फॉलोड बाय टू कंक्लूजन 1 and 2. Under the Environment Protection Act 1986, when an offence is committed by a company, every person who was directly in charge of and responsible to the company at the time of the offence, as well as the company itself, is deemed guilty. However, a person may escape liability if he proves that the offence was committed without his knowledge or that he exercised due diligence to prevent it. Conclusion है, a company as well as its responsible officers may be held liable for environmental offences under the act. An officer of a company can never escape liability once the company is found guilty of an offence. हमें बताना है कि कौन सा स्टेटमेंट इन दोनों में से करेक्ट है। ऑप्शन है हमारे पास ओनली कंक्लूजन 1, ओनली कंक्लूजन 2, या बोथ कंक्लूजन 1 and 2, या नाइदर कंक्लूजन 1 या नॉर सेकेंड फॉलोज। इसका करेक्ट आंसर हो जाएगा हमारा ऑप्शन नंबर ए, जो कि है फर्स्ट स्टेटमेंट। अ कंपनी एज वेल एज इट्स रिस्पॉन्सिबल ऑफिसर में बी हेल्ड लाइबल फॉर इन्वायरमेंटल ऑफेंसेस अंडर द एक्ट। नेक्स्ट क्वेश्चन देखेंगे। अंडर सेक्शन 24A ऑफ द इनकम टैक्स एक्ट 1961, व्हाट परसेंटेज ऑफ द एनुअल वैल्यू ऑफ एन इनकम फ्रॉम हाउस प्रॉपर्टी इज अलाउड एज ए स्टैंडर्ड डिडक्शन? ऑप्शन है 20, 40, 30 या 50। इसका करेक्ट आंसर हो जाएगा हमारा ऑप्शन नंबर सी, जो कि है 30। सेक्शन 24 क्लॉज ए में बताया गया है कि एनुअल वैल्यू कितनी होगी, 30% हो जाएगी स्टैंडर्ड डिडक्शन से। नेक्स्ट क्वेश्चन देखेंगे। आफ्टर गवर्नमेंट नोटिफिकेशन इज इशूड फॉर एक्वायरिंग मिस्टर मेहता's farmland under the Land Acquisition Act 1894, he notices that the income from his crops steadily decreases until the authorities finally take possession. He approaches the court claiming compensation for this reduction in profits. According to the act, what type of loss is compensable in such a case? First option, loss due to falling land prices in the market, loss due to cancellation of tenant agreements, loss of employment in nearby areas, bona fide diminution of profits due to acquisition process. इसका करेक्ट आंसर हो जाएगा हमारा ऑप्शन नंबर डी, जो कि है bona fide diminution of profits due to acquisition process। ये हमारा बताया है सेक्शन 23 क्लॉज ऑफ लैंड एक्विजिशन एक्ट 1894 में, जो कि बात करता है कंपनसेशन से। नेक्स्ट क्वेश्चन देखेंगे। अकॉर्डिंग टू सेक्शन 35A ऑफ CPC, व्हाट इज़ द मैक्सिमम अमाउंट ऑफ अ कोर्ट कैन अवॉर्ड एज अ कंपनसेटरी कॉस्ट इन ऑर्डिनरी केसेस? 2000 रुपीज़, 5000, 10,000 या 3000? सेक्शन 35A में कितनी कंपनसेटरी कॉस्ट बताई हुई है हमें? तो इसका करेक्ट आंसर हो जाएगा ऑप्शन नंबर डी, जो कि है 3000 रुपीज़। नेक्स्ट क्वेश्चन। अकॉर्डिंग टू द इंडियन कॉन्ट्रैक्ट एक्ट 1872, व्हेन इज द कम्युनिकेशन ऑफ एन एक्सेप्टेंस कंप्लीट अगेंस्ट द प्रोपोजर? ऑप्शन है व्हेन द एक्सेप्टर प्रिपेयर्स द लेटर ऑफ एक्सेप्टेंस, व्हेन इट इज डिस्पैच्ड बियॉन्ड द कंट्रोल ऑफ द एक्सेप्टर, व्हेन इट इज डिलीवर्ड टू द ऑफिस ऑफ द प्रपोजर पार्टी, व्हेन द प्रपोजर एक्नॉलेजेस रिसिप्ट इन हिज रिकॉर्ड्स। इसका करेक्ट आंसर हो जाएगा ऑप्शन नंबर बी, व्हेन इट इज डिस्पैच्ड बियॉन्ड द कंट्रोल ऑफ द एक्सेप्टर। नेक्स्ट क्वेश्चन। राहुल rents a shop in the city for running his retail business. Later, the landlord decides to terminate the lease. Since the lease is for purposes other than agriculture or manufacturing and there is no special contract between the parties, the landlord wonders how many days notice he must legally give under the TPA to end the lease. What is the required notice period? 5-day notice, 15 days notice, 45 days, 60 days notice? इसका करेक्ट आंसर हो जाएगा हमारा 15 डेज नोटिस। सेक्शन 106 जो कि डील करता है किससे, लीज से। लीज बताया गया है कि या तो एयर टू एयर होगी, जो एयर टू एयर वाली होगी वो टर्मिनेट होगी विद इन 6 मंथ नोटिस से, और एनी अदर पर्पसेस के लिए लीज टर्मिनेट हो जाएगी विद इन 15 डेज नोटिस के लिए। नेक्स्ट क्वेश्चन देखेंगे, अकॉर्डिंग टू द नेगोशिएबल इंस्ट्रूमेंट एक्ट 1881 व्हाट इज द मैक्सिमम सेंटेंस ऑफ इम्प्रिजनमेंट दैट अ मैजिस्ट्रेट में पास इन अ समरी ट्रायल अंडर सेक्शन 143? 6 months, 2 years, 1 year, 3 years? इसका करेक्ट आंसर हो जाएगा हमारा 1 year इम्प्रिजनमेंट। सेक्शन 138 में मैक्सिमम इम्प्रिजनमेंट बताई है 2 years की, और सेक्शन 143 में बताई है मैक्सिमम इम्प्रिजनमेंट 1 year की। नेक्स्ट क्वेश्चन देखेंगे, in the following question a statement is followed by two conclusion 1 and 2. As per section 157 of Companies Act, every company must within 15 days of receiving intimation under section 156 furnish the DIN of all its directors to the registrar with prescribed fees. Failure to comply attract penalties. Conclusion है हमारे पास, if a company fails to furnish the DIN it can also be penalized. Every officer of the company in default is also liable for penalties. इसका करेक्ट आंसर हो जाएगा हमारा ऑप्शन नंबर ए, जो कि है ओनली फर्स्ट स्टेटमेंट इज ट्रू। सभी मेंबर्स कंपनीज के लायबल नहीं होते पेनल्टी के लिए। नेक्स्ट क्वेश्चन देखेंगे, अंडर द इंफॉर्मेशन टेक्नोलॉजी एक्ट 2000 अ डिजिटल सिग्नेचर मे बी सस्पेंडेड बाय द सर्टिफाइंग अथॉरिटी ऑन द रिक्वेस्ट ऑफ द सब्सक्राइबर एंड ऑथराइज्ड रिप्रेजेंटेटिव और इफ इट इज कंसिडर्ड नेसेसरी इन द पब्लिक इंटरेस्ट. Under the same act, a digital signature can remain suspended indefinitely without providing the subscriber an opportunity of being heard. Options are both statements are false, only statement 1 is true, only statement 2 is true, both the statements are true. इसका करेक्ट आंसर हो जाएगा हमारा ओनली फर्स्ट स्टेटमेंट इज ट्रू। ये किसमें बताया, हमारा सेक्शन 37 क्लॉज 1 में बताया, सर्टिफाई अथॉरिटी में इशू अ DSC, एंड सेक्शन 37 क्लॉज 2 में बताया कि शैल नॉट बी सस्पेंडेड फॉर अ पीरियड एक्सीडिंग 15 डेज। नेक्स्ट क्वेश्चन देखेंगे, According to the Child and Adolescent Labour Act 1986, the appropriate government credits 15,000 to the Child and Adolescent Labour Rehabilitation Fund for each child or adolescent for whom the fine amount from the employer has been deposited. The amount in the fund is deposited or invested in banks, and the interest accrued is also payable to the child or adolescent. Conclusion, the child or adolescent is entitled not only to credited amount but also the interest accrued on it. The government is not required to deposit any money other than what is collected as fines from the employer. Which of the following statement is correct? इसमें हमारा ऑप्शन नंबर ए हमारा सही हो जाएगा, जो कि फर्स्ट स्टेटमेंट बिल्कुल ही सही है। नेक्स्ट क्वेश्चन देखेंगे, The BNS prescribes the death penalty for certain forms of gang rape. The purpose of this provision is to make all sexual offences non-bailable. Both A and R are true, and R is the correct explanation. Both A and R are true, but R is not the correct explanation. A is true, but R is false. A is false, but R is true. सो इसमें देखेंगे कि हमारी ये जो फर्स्ट स्टेटमेंट बताई है डेथ पेनल्टी फॉर सर्टेन फॉर्म्स ऑफ गैंग रेप, वो बिल्कुल ही सही हो जाएगी, और रीज़न हमारा इसमें गलत हो जाएगा। नेक्स्ट क्वेश्चन देखेंगे, अंडर द भारतीय नागरिक सुरक्षा संहिता 2023 इफ द प्रोक्लेम्ड पर्सन अपेयर्स विद इन द टाइम स्पेसिफाइड इन द प्रोक्लेमेशन द कोर्ट शेल रिलीज द अटैच्ड प्रॉपर्टी। रीज़न है हमारा, द अटैचमेंट ऑफ प्रॉपर्टी अंडर द भारतीय नागरिक सुरक्षा संहिता 2023 इज इंटेंडेड टू कंपेल द अपेयरेंस ऑफ द प्रोक्लेम्ड पर्सन बिफोर द कोर्ट, नॉट टू परमानेंटली डिप्राइव हिम ऑफ हिज प्रॉपर्टी. विच ऑफ द फॉलोइंग स्टेटमेंट इज करेक्ट? तो इसमें हमारा करेक्ट आंसर हो जाएगा बोथ स्टेटमेंट्स ट्रू है, और रीज़न इसका बिल्कुल ही सही है। नेक्स्ट क्वेश्चन देखेंगे, रीड द गिवन स्टेटमेंट एंड चूज द करेक्ट आंसर. एन आर्बिट्रेशन एग्रीमेंट मस्ट बी इन राइटिंग एंड इट कैन बी कंटेन्ड इन एन कॉन्ट्रैक्ट एंड एक्सचेंज ऑफ लेटर्स, टेलेक्स, टेलीग्राम्स और इलेक्ट्रॉनिक communication. Statement 2 है, an arbitration agreement may be implied solely from the conduct of the parties without any written record. फर्स्ट स्टेटमेंट ट्रू है, सेकंड ट्रू है, या बोथ स्टेटमेंट ट्रू है, या नाइदर फर्स्ट नॉर सेकंड इज ट्रू. तो इसमें हमारी स्टेटमेंट 1 इज ट्रू हो जाएगी. नेक्स्ट क्वेश्चन. According to the Advocate Act, when the term of a state bar council expires without an election, the Bar Council of India shall constitute a special committee consisting of the ex officio members of the State Bar Council as chairman and 2 nominated members. The special committee has the power to discharge all the functions of the State Bar Council until the new council is constituted, and election must be held within 6 months unless the period is extended by the Bar Council of India. Conclusion है, the special committee is empowered to handle pending disciplinary matters of the State Bar Council. The Bar Council of India may extend the 6-month period for holding elections to the State Bar Council for recorded reasons. Which of the following statement is correct? तो इसमें हमारा ऑप्शन नंबर सी जो हो जाएगा वो दोनों स्टेटमेंट्स हमारी ट्रू हो जाएगी. नेक्स्ट क्वेश्चन देखेंगे. अंडर द IT Act 1961, a deduction equal to 30% of the annual value is attained while computing income from the house property where the property has been acquired or constructed with borrowed capital. The maximum deduction for interest payable on such capital is capped at 2 lakh subject to conditions. Which of the following is true? सो इसमें हमारा ऑप्शन नंबर डी हमारा सही हो जाएगा. जैसे कि स्टेटमेंट 1 है, विच डील्स विद सेक्शन 24 क्लॉज 1 ऑफ द IT Act 1961 विच प्रोवाइड्स फॉर द स्टैंडर्ड डिडक्शन. इट स्टेट्स दैट अ सम इक्वल टू 30% ऑफ द एनुअल वैल्यू shall be deducted from the net annual value of the property. So first statement is true, and by analyzing statement second, section 24 clause B, which deals with the deduction of interest on borrowed capital, so statement 2 is correct. Next question. Under the Hindu Succession Act 1956, a daughter in a joint Hindu family governed by Mitaksha law becomes a co-partner by birth in her own right, just like a son. Reason: this provision grants daughters the same rights, liabilities, and disabilities in co-partner property as those of the son. In the context of the above assertion and reason under the Hindu Succession Act 1956, which one of the following is correct? So option A is correct. Both A and R are true, and R is the correct explanation of A. Section 6 clause 1 of the act explicitly states that the daughter of the co-partner shall by birth become a co-partner in his own right in the same manner as the son. Thus A is the assertion is true. And reason: section 6 clause 1 further states that she shall have the same rights in the co-partner right as she would have had if she had been a son, and she is subject to the same liability. So reason is also correct. So option A is correct. Both A and R are true, and R is the correct explanation of A. Next question. As per the Indian Contract Act 1872, an acceptance must be absolute and unqualified. What is the legal effect if the offer is response to a proposal introduces a new term? It becomes a valid acceptance, and the new term is incorporated as a mere suggestion. It operates as a valid acceptance if the new term is not a material alteration. It constitutes a counter proposal, thereby rejecting the original proposal. It suspends the original proposal until the new term is accepted or rejected by the proposer. So correct answer is Option number C, it constitutes a counter proposal, thereby rejecting the original proposal. Section 7 of the Indian Contract Act 1872 states that acceptance must be absolute and unqualified. That's why option C is correct. Next question. The Indian Contract Act 1872 provides for specific situation where an agreement without consideration is not void. Which of the following agreement is valid despite the lack of fresh consideration? Options are: an oral promise by A to pay B rupees 5,000 for a service B voluntarily rendered to A last month, a written and registered promise by a husband out of natural love and affection to transfer a property to his wife, a promise to subscribe rupees 1 lakh to public charitable fund, a promise made by a minor upon attaining majority to pay a debt incurred during his minority. Correct answer is option number B. Next question. In the context of delegated legislation, the judicial doctrine that prevents a legislation from conferring uncontrolled legislative powers on the administration is known as which doctrine? Ultra vires, excessive delegation, conditional legislation, separation of power. Correct answer is option number B, excessive delegation. Next question. For a petition for nullity of marriage under the Hindu Marriage Act 1955 on the ground that consent was obtained by fraud, what is the statutory bar to granting the decree? The petition was filed more than 6 months after the discovery of the fraud. The petitioner has lived with the respondent as husband and wife after the discovery of the fraud. The fraud relates to social status of the respondent family. The parties have not attempted reconciliation through a counseling center. Correct answer is option number B. The petitioner has lived with the respondent as husband and wife after the discovery of the fraud. Next question. In the absence of an agreement between the parties, the arbitration proceedings are said to have commenced under Section 21 of the Arbitration and Conciliation Act 1996. On the date of the appointment of arbitrator, on the date the arbitration agreement is signed. C option is on the date the request for reference is received by the respondent, on the date the arbitral tribunal issues notice. Correct answer is option number C, on the date of the request for reference is received by the respondent. It is given under Section 21 of the Arbitration and Conciliation Act 1996. Next question is, which of the following public interest litigation expanded Article 21 of the Indian Constitution to include right to enjoyment of pollution-free water and air? Subhash Kumar versus State of Bihar, B option Neelavati Behra versus State of Orissa, C option Sheila Barse versus Union of India, D option Olga Tallis versus Bombay Municipal Corporation. Correct answer is Subhash Kumar versus State of Bihar, which deals with the right to enjoyment of pollution-free water and air. Next question. Which public interest litigation case resulted in the Supreme Court of India laying down the principle of absolute liability? MC Mehta versus Union of India, AIR 1987, 1988, MC Mehta versus Kamal Nath 1997, MC Mehta versus Union of India 1997. So correct answer is option number A, MC Mehta versus Union of India, which is also known as oleum leak gas. Next question. In which of the following cases the Supreme Court of India has pointed out that the rule of nemo judice in causa sui is subject to the doctrine of necessity? Correct answer is option number C, J. Mohapatra and Company versus State of Orissa. Next question. Section 11 of the CPC 1908 for res judicata to be applicable on a subsequent suit. The former suit, options are, has been finally decided, can only be instituted prior to the subsequent suit, relates to the same matter directly and substantially in issue in the subsequent suit, is between the same parties or between parties under whom they or any of them claim. In this regard, our statement number 2 is incorrect. So option number C is correct. First, third and fourth. Next question. Question number 62. Where the decrees for payment of money execution by detention in prison shall not be ordered unless after giving the judgment debtor an opportunity of showing cause, the court is satisfied that judgment debtor is likely to abscond or leave the local limits of jurisdiction. Judgment debtor has before the institution of the suit in which the decree was passed dishonestly transferred any property of his property, decrees for a sum for which the judgment debtor was bound in a fiduciary capacity to account. Judgment debtor has or has had since the date of the decree the means to pay substantial amount of the decree and neglected to pay the same. So here our 4 statements are correct. Next question. As per the CPC 1908, a decree ex parte can be set aside against a defendant. Options are: if he satisfied the court that the summons was not duly served, if he satisfied the court that he was prevented by any sufficient cause from appearing when the suit was called on for hearing, if he satisfied the court that there has been an irregularity in the service of summons despite the fact that the defendant had notice of the date of hearing and had sufficient time to appear and answer the plaintiff's claim without notice being served on the opposite party. Select the correct answer. So our option number A is correct. Only first and second statement are true. Next question. When is a confession made by a person in police custody admissible under the Bharatiya Sakshi Adhiniyam? Options are: only if it is made voluntarily in writing, only if it is made in the immediate presence of magistrate, only if it is supported by 2 independent witnesses, only if it is recorded after the charge sheet is filed. So correct answer is option number B, only if it is made in the immediate presence of a magistrate. Next question is, which section of the Bharatiya Sakshi Adhiniyam 2023 pertains to opinion of experts? Section 38, Section 39, Section 36 and Section 46. So correct answer is option number B, Section 39, which deals with opinion of experts. Next question is, which of the following statements is incorrect as per the Bharatiya Sakshi Adhiniyam 2023? A contracts in writing with B for the delivery of indigo upon certain terms. The contract mentions on the fact that B had paid A for the price of other indigo contracted verbally or another occasion. Oral evidence is offered that no payment was made for the other indigo. The evidence is admissible. Second option is A agrees absolutely in writing to pay B 1000 rupees on 1st March 2023. The fact that at the same time an oral agreement was made so that the money should not be paid till 31st March. C option is A enters into a written contract with B to work certain mines, the property of B upon certain provisions. A was induced to do so by misrepresentation of B as to their value. This fact may be proved. For fourth option है A orders goods from B by a letter in which nothing is said as the time of payment and accepts the goods on delivery. B sues A for the price. A may show that the goods were supplied on credit for a term still expired. Correct answer is option number B. Next question. As per the Hindu Marriage Act, 2 persons are said to be within the degree of prohibited relation. Options are: one is a lineal ascendant of the other, including relationship by adoption. One was the wife or husband of a lineal ascendant or descendant of the other, including relationship by half or uterine blood as well as by full blood. One was the wife of the brother or of the father's or mother's brother, of the grandfather's or grandmother's brother of the other. Next is the two are brother and sister, uncle and niece, aunt and nephew, or children of brother and sister, or of 2 brothers or of 2 sisters. So here all the 4 statements are correct. So option number D is correct. Next question. Which of the Which article of the Constitution of India lays down the fundamental duty of every citizen to protect and improve the natural environment? Article 48A, Article 39A, Article 51AG, Article 51A Clause H. So correct answer is option number C, Article 51A Clause Sub G, which deals with the fundamental duty of every citizen to protect and improve the natural environment. Next question. The ground for decree for dissolution of marriage under section 2 of the Dissolution of Muslim Marriage Act 1939 are that the whereabouts of the husband have not been known for a period of 2 years, husband has been sentenced to imprisonment for a period of 5 years, husband has failed to perform without reasonable cause his marital obligations for a period of 2 years, husband has neglected or has failed to provide for maintenance of his wife for a period of 1 year. Select the correct answer. So here all the statements are wrong, so option number D is correct, none of this. Next question, and this is the last question. As per the Information Technology Act 2000, intermediary with respect to any particular electronic records means any person who on behalf of another person receives, stores or transmits the that record or provides any service with respect to that record and includes. Options are telecom service providers, search engines, cyber cafes, online auction sites. So here all the statements are correct.